I was up super late last night just staring at this massive stack of legal research.
Berkeley.
Yeah, this huge dossier on global wealth structuring, specifically, comparing trusts and foundations. And honestly, it completely broke my brain regarding how we actually view ownership.
Right. It's a heavy topic.
It really is. I mean, usually when we talk about, say, a medical diagnosis or engineering, there's this expectation of absolute precision. Like you break your arm, the x-ray shows that jagged white line, and the doctor just points and says, there it is, broken.
It's binary. You're either holding the asset or you aren't.
Yep.
We like things to be visible, categorized, neatly boxed up.
Exactly. But then you step into the world of global wealth structuring, and suddenly that x-ray machine is just feeding you static.
Oh, right.
We're looking at a financial landscape that is, well, it's intentionally opaque to the untrained eye. Because for most of us, terms like trust fund and private foundation, they just sound like synonyms for the exact same thing, like rich people stuff.
Yeah, they just sound like a vault.
Right. We imagine a giant, cartoonish steel vault where billionaires lock away their cash, maybe with a brass plaque on the front.
It is the absolute definition of diagnostic muddy waters. Because when you actually look under the hood of these structures, a trust and a foundation are fundamentally different tools. I mean, they originate from entirely different legal universes.
Right.
They aren't just two types of steel vault holding gold bars. They operate on completely different laws of physics when it comes to property rights and liability and control.
And realizing that those laws of physics are different is, I think it's the first step to true financial literacy at the highest level.
Absolutely.
And that is exactly what we are doing today. Welcome to the deep dive. Whether you are, an aspiring family office director, a financial professional prepping for a major client meeting, or you're just insanely curious about how the ultra-wealthy legally protect their empires from taxes and lawsuits, you are in the right place.
We've got a lot of ground to cover.
We really do. We're going to extract the ultimate jargon-free guide on these two titans of wealth preservation. We're going to compare U.S. and foreign structures, decode the obscure jurisdictions from South Dakota to the Cook Islands to Liechtenstein, navigate the intense new global banking rules, and uncover how combining these tools creates the ultimate financial fortress.
It's quite a journey.
Okay, let's unpack this. We have to start at the absolute bedrock, the DNA of these structures. Let's talk about relationships versus entities.
That is the crucial starting line, because this is where the biggest foundational misconception really lies. Let's look at the trust first.
Okay.
So a trust originates from common law. That's the legal system that developed in England centuries ago. And here is the vital concept that trips up almost everyone. A trust is not a legal entity.
Wait, really?
Not an entity. It is not a company. It does not exist as a standalone person in the eyes of the law. It is fundamentally just a relationship.
Not an entity. Okay, that bends the mind a little. If you're used to thinking of a trust as a corporate box with a tax ID number, if it's not a thing, how does it hold money?
Right, so it relies on a concept called bifurcation, which simply means splitting ownership in half.
Okay.
You have the settler. That's the person who actually made the money. They take the legal title of their assets and physically hand it over to a trustee.
So the trustee gets it.
Yes. The trustee now legally owns those assets. Their name is on the deed to the house. Their name is on the brokerage account. But, and this is the key, they don't own them for their own enrichment. They hold them for the equitable benefit of the beneficiaries.
So the trustee is on the deed. They are dealing with the property taxes and the stock trades, but the beneficiary gets the actual economic joy of the asset.
Yes. The legal ownership and the beneficial enjoyment are severed. That bifurcation is the absolute hallmark of the trust. It operates entirely on a body of fiduciary obligations.
And fiduciary obligation is pretty strict, right?
Oh, incredibly strict. It isn't just a suggestion to do a good job. It is a strict legal mandate enforced by courts of equity. The trustee is legally barred from putting their own interests above the beneficiaries. If they use the trust money to buy themselves a sports car, they have breached that fiduciary duty, and the courts will bring down the hammer.
Okay, I want to make sure we really nail this visualization so we don't get lost in the legal weeds here. Let's say a trust is like a backpack you hand to a highly reliable friend.
Okay, I like that.
And that friend is the trustee. You give them a list of strict instructions on who gets the supplies inside the backpack and when.
Right.
The friend is the one wearing the backpack. They are legally carrying it around. They are responsible if it gets left in the rain, but they absolutely cannot eat the protein bars inside. Those bars are exclusively for your kids, the beneficiaries.
I think that analogy perfectly captures the burden of the trustee. They carry the weight, but get none of the nutrition.
That makes sense. Now, contrast that relational backpack with a foundation, because just the word foundation feels entirely different.
It is entirely different. So
Yep.
the private foundation originates from civil law, think continental Europe, Latin America, jurisdictions heavily influenced by Roman law.
Okay.
A private foundation is a distinct legal entity. It has its own legal personality, just like a corporation or a living, breathing human being.
So it is a thing.
Yes. The founder endows it with assets, a foundation council manages it, and the foundation owns its assets directly, in its own name. There is no splitting of ownership here at all.
So if the trust is handing a backpack to a friend, a foundation is like building a robot.
The robot.
Yeah, you program it with instructions, which is the foundation's charter, and the robot physically owns the supplies itself. It walks around, it can sign contracts with this robotic hand, it can hold a bank account in its own robotic name.
That is a phenomenal way to differentiate them.
Huh.
The robot is autonomous under the law, and here is why this distinction matters so profoundly in the real world. Liability. Let's say something goes catastrophically wrong with one of the assets. Maybe a piece of real estate owned by the structure has a toxic spill, and there's a massive environmental lawsuit.
Oh, wow. Okay.
If a trust is sued, you literally have to sue the trustee personally, because the trust isn't a person that can be sued.
You're suing the friend wearing the backpack?
Exactly. The trustee is personally liable, though they are usually indemnified, meaning they can pay the legal judgments using the assets inside the backpack.
But if a foundation is sued for that same toxic spill...
The foundation itself is liable. You sue the robot. The legal entity takes the hit, completely shielding the foundation council, the people operating the robot's controls, from any personal liability. The council members sleep soundly because their personal bank accounts are never at risk.
That is a massive difference in how you sleep at night if you are managing the money. But it immediately brings up a pretty terrifying thought for the person actually funding the structure.
The control aspect.
Yeah. If I'm giving away my life savings, my business, my real estate to a trustee with a backpack or to a programmed robot, how do I make sure they don't completely mess it up? I built the wealth. I want to keep control.
Which brings us to the great paradox of wealth structuring, the control dilemma. Settlers and founders want to give their assets away so creditors, ex-spouses, or tax authorities can't touch them. But human nature dictates that they still want to pull the strings.
Right. You want your cake, you want to lock it in an impenetrable vault, but you still want to be able to eat a slice whenever you feel like it.
That is the goal of every single client. But the legal system is acutely aware of this desire, and they've developed rules to prevent it. In the common law trust world, we have something called the sham trust doctrine.
Trust.
Right. If you set up a trust, but you retain too much control, a court will look at that and say, this isn't a real trust. This is a sham. It's just a nominee arrangement.
What does too much control actually look like in practice, though? Give me an example of how someone accidentally creates a sham trust.
Okay, let's say you put $10 million into a trust, and you name your lawyer as the trustee. But in reality, you keep the trust's checkbook in your bottom drawer.
Oh, I see.
Yeah, you use the trust funds to buy groceries, you pay your personal country club dues out of the trust account, and you text the trustee daily demanding they buy specific stocks. Furthermore, the trust document says you can fire the trustee at any moment for any reason.
That sounds like you're just using them as a puppet.
Exactly. If a creditor sues you and discovers this behavior, the judge will pierce right through the trust. They will declare that the bifurcation of ownership never actually happened. The asset protection vanishes instantly.
Because you never actually gave up the protein bars in the backpack.
Right.
So how did the ultra-wealthy solve that? How do they get comfortable handing over millions without triggering this sham trust doctrine?
They use a mechanism called a protector.
A protector?
Yes, this is an incredibly common, highly engineered offshore trust solution. The settler appoints a trusted third party, perhaps a retired judge, a longtime family advisor, or a specialized legal firm to act as the protector.
And what do they do?
Well, the protector does not manage the money. They do not pick the stocks. But they have negative control.
Meaning they can't force the trustee to do something, but they can stop them from doing something stupid.
Correct. The protector can veto the trustee's distribution decisions. Most importantly, they have the power to fire and replace the trustee.
Oh, wow.
It gives the settler immense peace of mind because they know someone is watching the trustee. But it doesn't trigger the sham trust doctrine because the settler technically isn't the one holding the veto pen. It creates a necessary degree of separation.
Okay, that makes sense for the trust side. You need this complex web of trustees and protectors to balance control and protection. What about the foundation side? If I build the civil law robot, can I just keep the remote control?
In the civil law foundation world, the control issue is vastly cleaner. Yeah. Because the foundation is a separate, freestanding legal entity, the rules governing it are entirely different from the relational rules of a trust. In jurisdictions like Panama or Liechtenstein, the founder can literally sit on the foundation council.
You can sit on the council of the robot you built.
Yes. You can be named as the primary beneficiary. You can even retain the legal right to revoke the entire foundation and take all your assets back whenever you want, and none of that destroys the legal validity of the foundation.
Wait, I have to push back on that. That sounds like a massive loophole. So in Panama, I can build the robot, write the code, serve on its board of directors, receive all the money it generates, and retain a self-destruct button to take it all back?
You can.
Why doesn't every single wealthy person on Earth just do that? It sounds foolproof compared to dealing with protectors and fiduciary duties.
It does sound like a silver bullet. But to understand why it isn't, we have to look at the historical timeline of these legal systems. It comes down to a concept called perpetuity and the rule against perpetuities, or RAP.
Rule against perpetuities.
Yes. This is an ancient common law rule that essentially said you cannot control property from the grave forever. The English courts were terrified of wealthy lords locking up vast tracts of land for centuries, preventing economic development.
That makes sense.
So, historically, trusts had a strict time limit. They could only last for a life in being plus 21 years.
Okay, so if I set up a trust, I pick someone alive today, say my newborn grandchild. The trust can last for their entire life, plus another 21 years after they die, so roughly 90 to 100 years max.
Right, and then the trust has to burst open, distribute all the assets, and dissolve. The wealth was forced back into the open market.
Wow.
Foundations, on the other hand, originating in civil law, did not have this restriction. They were always perpetual. They could last forever.
So if you were a wealthy family looking to build a 300-year dynasty, civil law foundations looked incredibly attractive. You didn't have to worry about the 100-year ticking clock.
Exactly. But the legal world is a highly competitive marketplace. Common law jurisdictions realized they were losing massive amounts of capital to these perpetual foundations. So modern trust jurisdictions, places like South Dakota, Delaware, and offshore havens like the Cayman Islands, they simply passed laws abolishing the rule against perpetuities.
Just got rid of it.
Yes, they birthed the dynasty trust. Now, trusts can last for centuries or even forever, neutralizing the foundation's historical advantage.
The free market of legal systems at work. If a rule is costing you billions in trust management fees, just rewrite the rule.
Pretty much.
But you still haven't fully answered why everyone doesn't just use a Panama foundation for the ease of control. There has to be an asset protection vulnerability.
There is. And it brings us to the concept of fraudulent transfer lookbacks.
Lookbacks, okay.
This is the ultimate ticking clock in asset protection. If you get sued and you suddenly move all your money into a trust or foundation the very next day, a judge will look at the timing, declare it a fraudulent transfer designed specifically to avoid a creditor, and they will reverse the transfer.
They just pull the money right back out.
Yes, the assets will be seized. But every jurisdiction has a statute of limitations, a look-back period. If you move the money before the problem arises and the clock runs out, the assets are legally safe, regardless of how much control you have.
So it's a race against time. Once the clock hits 0, the vault is locked. How long are these clocks?
This is where jurisdictions compete fiercely. The Cook Islands is considered the absolute gold standard for asset protection trusts because their look-back period is incredibly short, often just 1 to 2 years depending on the specific circumstances.
That's nothing.
It's very fast. If a creditor doesn't file a claim in the Cook Islands within that tiny window, they are permanently barred. The Cayman Islands has a 6-year look-back. Foundations typically sit somewhere between 2 to 5 years depending on the country.
I see. So it's not just about what the structure is, it's about the specific local laws protecting it. I also noticed research mentioned something called forced heirship. What is that, and how do these structures interact with it?
Forced heirship is a reality in many civil law countries across Europe, Latin America, and the Middle East. It means you are legally forced to leave a certain percentage of your wealth to your children or spouse no matter what.
No matter what.
Yes, you cannot disinherit them even if you are estranged. Your will is essentially overridden by state mandate. Both offshore trusts and private foundations are heavily utilized to block these laws.
So if I live in France and I despise my adult children, but French law says I get 50% of my estate, I just take my assets, fly to the Cayman Islands or Liechtenstein and put them in a structure there.
Yes. You fund a Cayman trust, and the Cayman legal statutes explicitly state that local Cayman courts will ignore the forced heirship claims originating from your home country.
Wow.
The French court can yell all it wants, but the Cayman trustee will not release the funds to your children. The structure actively repels the foreign law.
Okay, so a Panama or Liechtenstein foundation sounds amazing for control, and a Cook Islands trust sounds impenetrable for lawsuits. But I know there has to be a massive catch, especially for our listeners based in the United States.
There is a monumental catch. If you are a U.S. citizen, a U.S. resident, or even just holding a green card, your local tax authority, the IRS, has highly complex, incredibly strict rules that make foreign foundations not just inefficient, but potentially ruinous from a tax perspective.
Ruinous!
Yes. For U.S. persons, the domestic tax code makes local, U.S.-based structures uniquely necessary.
Which brings us to the sprawling ecosystem of the U.S. domestic landscape, the alphabet soup of wealth planning and the incredibly strict rules that govern it.
It is an alphabet soup.
Let's look at the U.S. trust ecosystem first. For anyone who has ever sat down with an estate planner, you've almost certainly been pitched a revocable living trust, an RLT.
Yes, the RLT is the absolute workhorse of middle-class and upper-middle-class U.S. estate planning. But the research dossier is brutally clear on this point. An RLT provides zero tax protection and zero creditor protection.
Let's break down why. It's in the name revocable.
Right.
Because you can change your mind at any time, take the assets out, or dissolve the trust. The IRS looks at it and says, you still have total control, so for tax purposes, that's still your money. A judge in a lawsuit says the exact same thing, so what's the point of it?
The point of an RLT is avoiding probate.
Ah, probate.
Probate is the public court-supervised process of distributing your assets after you die. It is slow, it is expensive, and it is entirely public record. An RLT bypasses probate. It allows your assets to pass to your children privately and smoothly.
But if you are ultra-wealthy, avoiding probate isn't your primary concern.
Not at all. Your primary concern is the 40% federal estate tax that hits when you die. To avoid that, you have to step out of the revocable world and into the world of irrevocable trusts, the alphabet soup.
And this is where the legal engineering in the U.S. system just gets staggering. Let's walk through a few of these acronyms to understand the mechanics. Let's start with the ILIT, the Irrevocable Life Insurance Trust.
The ILIT is foundational for estate liquidity. If you have a $50 million estate, the IRS is going to demand roughly $15 to $20 million in estate taxes 9 months after you die.
9 months, that's fast.
Exactly. And if your wealth is tied up in illiquid real estate or a private business, your kids might have to hold a fire sale just to pay the tax bill.
Yikes.
So you buy a massive life insurance policy. But if you own the policy yourself, the payout is added to your taxable estate, making the problem worse.
So you get taxed on the money meant to pay the taxes.
Yes. The solution is the ILIT. The trust owns the policy. When you die, the trust receives the $20 million payout tax-free outside of your estate and uses that cash to pay the IRS.
It's essentially buying a massive umbrella just for the day you know a storm is going to hit. Then you have the Spousal Lifetime Access Trust.
The SLAT is a brilliant workaround for the control dilemma we discussed earlier. You want to move assets out of your taxable estate, but you don't want to completely lose access to the money while you're alive.
Right.
So you create an irrevocable trust for the benefit of your spouse. You gift the assets to the SLAT, removing them from your estate. But because your spouse is the beneficiary, they can request distributions from the trustee. As long as you are happily married, you indirectly benefit from the wealth you just gave away.
And then there's the grantor retained annuity trust. I want to spend a minute on this one because the math behind it feels like a sanctioned magic trick. How does a GRAT actually work?
A GRAT is designed to transfer explosive growth to the next generation without paying gift or estate taxes. Here is the mechanic. You take an asset that you believe is about to skyrocket in value. Let's say $10 million worth of pre-IPO stock in your tech startup.
Okay, a high-growth asset.
You place it into the GRAT. The rules of the jurat state that the trust must pay you back a fixed annuity every year for a set term, say 3 years.
So I give it $10 million, and it slowly pays me back my $10 million.
Exactly, plus a modest interest rate mandated by the IRS, called the Section 7520 rate. Let's say that government rate is historically low, around 4%. So the trust owes you back your original $10 million plus 4% interest. But what happens if your startup goes public and that stock doubles in value to $20 million?
The trust pays me back my $10 million plus the 4% interest, but what happens to the massive delta, the extra $9+ million of explosive growth?
That is the magic. All of that excess growth above the 4% hurdle rate
Yeah.
passes to your children, the beneficiaries, completely tax-free.
Tax-free.
Yes.
Yeah.
You haven't used any of your lifetime gift tax exemption because technically you only gifted an asset that you got paid back for. It is essentially a heads-you-win, tails-you-tie scenario. If the stock drops in value, the jurat just fails, the shares come back to you, and you are no worse off than when you started.
That is wild. And it leads us right to the IDGT, Intentionally Defective Grantor Trust. I love that name. Intentionally defective. It sounds like you hired an aerospace engineer to build you a broken airplane on purpose. Why would a billionaire want a defective trust?
Yeah, because it exploits a fascinating disconnect between two different branches of the IRS. It is defective for income tax purposes, but is perfectly valid for estate tax purposes.
Walk me through that disconnect.
When you set up an IDGT, you include specific clauses that trigger the grantor trust rules. This means the income tax division of the IRS looks at the trust and says, this is a sham, you retain too much power, so you personally must pay all the income taxes on whatever this trust earns.
Wait, so if the trust makes $1 million in dividends, the trust pays 0 tax, and I get a tax bill in the mail for the $1 million? That sounds terrible.
It sounds terrible until you realize that the estate tax division of the IRS looks at the exact same trust and says, this is a perfectly valid, completed gift. These assets are out of your estate. Yep. So the assets inside the IDGT are growing completely tax-free, untouched by income tax drag, because you are burning your own personal cash outside the trust to pay its tax bill. And the IRS does not consider your payment of those taxes to be an additional gift to your children. You are legally allowed to subsidize the trust's growth. It's a stealth way to transfer millions of dollars in wealth tax-free.
You are intentionally taking the tax hit so your kid's inheritance compounds at absolute maximum velocity. Incredible.
It's very powerful.
And finally, in the U.S. landscape, we have the DAPT, the Domestic Asset Protection Trust. This is the holy grail for a lot of professionals like surgeons or real estate developers who have high litigation risk.
Yes, high liability professions.
It's a self-settled trust, meaning I am the settler, I put the money in, and D, I am a discretionary beneficiary. I can still ask the trustee for money, but my creditors can't touch it.
Right. Historically, the U.S. did not allow self-settled asset protection trusts. If you could get the money, your creditors could get the money. It was a matter of public policy.
That makes sense.
But in the late 1990s, states like Alaska, Delaware, Nevada, and South Dakota realized they could attract billions of dollars in trust business if they changed their laws to allow DAPTs. Today, roughly 20 states allow them, completely transforming the domestic asset protection landscape.
Now let's contrast all of that incredible hyper-engineered flexibility on the trust side with U.S. private foundations. Remember how we said a private foundation in Panama or Liechtenstein can be programmed just for your family's private benefit? You build the robot to just hand your kids money?
If you try to build that robot in the United States, the IRS will dismantle it and tax you to oblivion.
Wow.
In the U.S., a private foundation, which operates under Section 501c3 of the Internal Revenue Code, must be strictly and exclusively charitable. You absolutely cannot have a private interest foundation in America.
That is a massive philosophical divergence. In Liechtenstein, the government says, sure, use a foundation to protect your kids. In the U.S., the government says, if you want the legal and tax benefits of a foundation, you must serve the public good. They weaponize the tax code to force philanthropy.
Precisely. The U.S. offers a massive upfront tax deduction when you donate assets to a private foundation. But in exchange for that deduction, you enter a highly regulated, punitive environment.
Punitive how?
First, the foundation is subject to a 1.39% excise tax on its net investment income. It is not entirely tax-free. Second, you cannot just hoard the money. The foundation is legally mandated to distribute at least 5% of its total net asset value every single year to legitimate public charities.
So if you endow it with $100 million, you are forced to give away $5 million a year minimum or face severe penalties.
Yes. But the most aggressive rules are the prohibitions on self-dealing. The IRS assumes that wealthy families will try to use the foundation as a personal piggy bank.
Naturally.
So they strictly prohibit almost any financial transaction between the foundation and disqualified persons, which includes the founder, their family, and their businesses. You cannot loan money from the foundation to yourself. You cannot sell property to the foundation. You can't even rent office space from the foundation, even if you offer a fair market rate.
So it's totally quarantined.
Exactly. The penalties for self-dealing are draconian excise taxes that can wipe out the transaction entirely. Furthermore, a U.S. private foundation generally cannot own more than 20% of a for-profit business. They force you to diversify the holdings and focus on the charitable mission.
So bringing this back to you, the listener, if you are a high net worth individual in the U.S. and your primary goal is to protect your private family wealth from creditors and estate taxes, a private foundation is absolutely not the tool for you. It is a philanthropic vehicle.
Correct.
For private wealth, you are looking squarely at the trust ecosystem. Specifically, you are looking at domestic havens like South Dakota, Delaware, or Nevada. These states have zero state income tax, they have abolished the rule against perpetuity so your trust can last forever, and they have incredibly strong DAPT laws. The research points out that South Dakota in particular has built a booming, multi-trillion-dollar institutional trust industry. How did a sparsely populated Midwestern state become the trust capital of the world?
South Dakota looked at offshore tax havens and essentially reverse-engineered their statutes to be the onshore equivalent. They recognized that the wealthy wanted privacy, zero taxes, and perpetual asset protection. But they were increasingly terrified of the compliance headaches of going offshore.
Oh, that's smart.
South Dakota offered the perfect compromise offshore-level protection with onshore respectability and constitutional protections. They built an entire legal infrastructure, specifically catered to managing generational wealth.
But what if onshore respectability isn't enough? What if I look at the U.S. court system, the unpredictability of civil juries, and I say, I don't trust any domestic judge. I want to put my assets on an island behind a legal moat. If the U.S. domestic landscape is that robust, what pushes someone to go global?
Extreme litigation risk, the desire for absolute structural isolation, or simply holding international assets. This is where we look at the heavyweights of the offshore world. Let's start with the common law jurisdictions, the Caribbean and the British overseas territories. The Cayman Islands is an absolute titan here. They have a highly specialized corporate law infrastructure and something called the Star Trust.
What makes a Star Trust different from a regular trust?
A standard trust requires a human beneficiary to enforce it. A Star Trust is a statutory non-charitable purpose trust.
Purpose trust.
Yes, it doesn't even need human beneficiaries. It can be set up simply to hold a specific asset, like the shares of a family business, or to achieve a specific legal purpose. It decouples the trust from human beneficiaries, which provides unique tax and structuring flexibility alongside zero local taxes and an excellent globally recognized banking infrastructure.
That is fascinating. It's a trust that exists just to do a job, not necessarily to feed a person. And then there is the BVI, the British Virgin Islands. The research highlights something they created called the Vista Trust. Now, this is where the legal gymnastics get truly interesting. Earlier, we talked about fiduciary duty, how the trustee is legally mandated to protect the assets and not do anything risky. But that creates a massive problem for an entrepreneur, right?
It creates an insurmountable problem. Let's say you built a high-growth, high-risk tech company, and you want to put your shares into a trust for your kids. You hand the shares to a professional trustee.
Right.
That trustee looks at your volatile tech company, realizes they have a fiduciary duty to preserve capital, and decides, this is too risky, I need to sell these tech shares and buy safe treasury bonds. Or worse, they try to step in and micromanage how you run the company.
Which is an entrepreneur's worst nightmare. You gave away the shares to protect them, and now a banker in a suit is trying to tell you how to run your startup. How does the Vista Trust solve this?
A Vista Trust solves it by legally neutralizing the trustee's fiduciary duty regarding the underlying company. You explicitly write into the law that the trustee is forbidden from interfering in the company's management.
Forbidden.
Yes, they hold the shares, but they have no duty to monitor the business, no duty to intervene if the business loses money, and no power to fire the directors.
You are literally paying a highly qualified, expensive professional trustee specifically not to do their job. You are paying them to sit on their hands and stay completely out of your company's business. You get the creditor protection of the trust, but you keep total operational control as the director of the company. It's brilliant.
It perfectly bridges the gap between asset protection and operational control. Now, if you want pure, unadulterated asset protection, the kind of structure that doesn't just manage risk but actively laughs at lawsuits, you look at the Cook Islands or Nevis.
The absolute fortresses, the places that keep plaintiff attorneys up at night, why are they so untouchable?
It comes down to their statutory refusal to recognize foreign judgment.
Ah,
Let's say you are a doctor in California, and you get hit with a devastating $10 million malpractice judgment that exceeds your insurance. If your assets are in a California bank, the judge just orders the bank to seize the funds. But if your money is legally held inside a Cook Islands trust, the California judge has no jurisdiction.
none at all.
None. You cannot just take that California judgment, fly to the Cook Islands, hand it to a local judge, and collect. The Cook Islands law explicitly rejects foreign court orders.
So the plaintiff has to start entirely from scratch.
Exactly. The local court will tell the plaintiff to hire a local Cook Islands lawyer who, by the way, cannot work on contingency, meaning the plaintiff must pay them hundreds of dollars an hour up front. They have to start the trial all over again in the local jurisdiction under local laws. And here is the kicker. To prove a fraudulent transfer in the Cook Islands, the plaintiff must prove their case beyond a reasonable doubt.
Wait, beyond a reasonable doubt is a standard for criminal cases like murder. Civil lawsuits are usually just preponderance of the evidence, meaning 51% likely.
Exactly. The Cook Islands intentionally took the highest, most difficult criminal standard of proof and applied it to a civil debt collection case. It is astronomically difficult and wildly expensive for a creditor to win.
That is wild.
Furthermore, if the Cook Islands judge does rule against you, the local trustee can sometimes trigger a flee clause, picking up the trust's legal status and moving it to Nevis or another jurisdiction before the money can be seized.
Just moving goalposts.
It's the ultimate deterrent. Most creditors look at the legal mountain they have to climb, realize it will cost them millions just to attempt it, and they just settle for pennies on the dollar or give up entirely.
Okay, so those are the common law offshore heavyweights for Americans and Brits. Let's flip the map and look at the private interest foundation hubs. Where do the civil law folks, the Europeans, the Latin Americans, where do they go to build their robots?
Panama is incredibly popular, especially for Latin American families. The Panama Private Interest Foundation, or PIF, is structurally robust and very cheap to set up, but its primary draw is extreme privacy.
How private?
In many jurisdictions, you have to file the names of the beneficiaries in a public registry. In Panama, the foundational charter is public, but the specific regulations, the document that actually lists who gets the money, is kept completely private. It is a private deed held by the resident agent. However, the research dossier notes a significant caveat. Panama has occasionally landed on the FATF gray list.
FATF being the Financial Action Task Force, the global watchdog for money laundering.
Yes. Being on the gray list means global banks view money coming out of Panama with extreme suspicion. So there is a reputational risk and a banking friction cost to choosing the budget option.
If Panama is the budget option, the Honda Civic of foundations, what's the premium tier? What's the Rolls-Royce?
That would unequivocally be Liechtenstein. It is a tiny principality nestled between Switzerland and Austria, and it has engineered one of the most sophisticated wealth preservation laws on Earth. What's unique about Liechtenstein is that it has a dual civil and common law system.
So they mix both.
Yes. You can establish a classic family foundation called a Stiftung, which offers immense asset protection and is deeply respected by European courts. Or you can use a highly unique hybrid entity called an Anstalt, or establishment.
An Anstalt, what makes that different from a regular foundation?
A normal foundation, like a Stiftung, is typically restricted to holding passive assets like shares in a company or a real estate portfolio. It usually cannot engage directly in active commercial trade. The Anstalt, however, is a hybrid. It has no shareholders, it functions like a foundation for asset protection, but it is legally allowed to run a commercial business directly.
So it can actually do business?
Yes, an Anstalt can operate a factory, trade goods, or provide consulting services while still offering the privacy and succession benefits of a foundation. Plus, Liechtenstein offers access to premium, ultra-exclusive private banking like LGT or VP Bank and maintains a very reasonable 12.5% corporate tax rate. It is highly respected, highly compliant, and very expensive.
I've also heard Austria mentioned in these circles. But Austria isn't exactly a sunny Caribbean tax haven with 0% corporate rates. Why would anyone go there?
The Austrian private Stiftung is heavily utilized by Eastern European wealth. You are correct, it's not a tax haven. They have a corporate tax rate hovering around 25%.
Right.
However, wealthy families use Austria not to eliminate tax, but for its massive, highly effective network of double taxation treaties. If you have Operating businesses across Eastern Europe, funneling the profits through an Austrian foundation is incredibly efficient for moving money legally across borders without getting hit by withholding taxes in every single country.
So if we pull back and look at the whole board, you can see a distinct geographical and cultural split. Anglo-Saxon clients, Americans, Brits, Australians, we instinctively understand and trust the backpack analogy. We are comfortable with fiduciary duty, so we gravitate toward Caribbean or Channel Island trusts. But continental European and Latin American clients prefer the robot. They prefer Panama or Liechtenstein foundations.
That cultural comfort is a massive driver, but there is also a very pragmatic legal reason for the split. Imagine a wealthy German family puts their manufacturing empire into a Cayman Islands trust.
Okay.
Decades later, the patriarch dies, and there was a bitter succession dispute among the children. One of them files a lawsuit in a German court. The German judge looks at the Cayman trust deed, looks at this common law concept of split equitable ownership and fiduciary relationships, and says, I don't know what this is. This doesn't exist in German civil law. I am going to ignore it entirely and just apply standard German inheritance law. The entire structure collapses because the local court couldn't comprehend it.
Ah, so it's a translation issue.
Exactly. But if that same German family uses a Liechtenstein Stiftung, the German judge recognizes it immediately. It is a separate legal entity, a concept fully ingrained in civil law. Civil law courts respect civil law structures. So you must build the structure in a legal language your home country will understand, or at least respect.
That makes perfect sense. Okay, so let's play this out practically. Let's say I've made my choice. I'm an American, I've got my Cook Islands Trust. Or I'm a Colombian family office and I've set up my Panama Foundation. The ink is dry on the documents, the lawyers have been paid. But here is a very real, everyday problem. How do I actually buy a cup of coffee or fund a tech startup or buy a piece of commercial real estate in London? I need a bank account. I can't just hand a real estate agent a 50-page trust deed and expect them to give me the keys.
And that very practical problem brings us to what is arguably the most difficult grinding aspect of modern wealth structuring, the banker's gate and the taxman. The regulatory reality of doing this in 2026.
We hear so much in movies about the good old days of offshore banking. The Jason Bourne scenario, you fly to Geneva, walk into a pristine lobby, hand over a steel briefcase of bearer bonds or cash, and the banker gives you an anonymous numbered account with no questions asked.
Those days are not just gone, they have been vaporized. The post-2008 financial crisis, combined with massive data leaks like the Panama Papers, changed the global financial system forever. The dossier outlines a phenomenon called the de-risking challenge. You have to understand that massive global correspondent banks, the institutions like JP Morgan or Citibank, that actually clear U.S. dollars and move them around the world, are terrified. They have paid billions of dollars in fines for inadvertently facilitating money laundering. So their compliance departments have systematically started dropping what they call challenge tier jurisdictions.
Meaning if your perfectly legal, beautifully drafted foundation happens to be registered in Panama, Belize, or the Seychelles,
you are going to have a brutal time finding a top-tier bank willing to hold your money, especially if you want to transact in U.S. dollars. The banks look at the origin of the entity and decide that the compliance risk simply isn't worth the management fees. They are heavily favoring premium tiers like Cayman, Jersey, Switzerland, and Liechtenstein. Why? Because those places have incredibly strict, highly audited local regulations that the big compliance departments at the major banks actually trust.
So even if you get past the geographic bias, let's say you have a premium Cayman trust, just opening the account is no longer a handshake deal. Tell me about the KYC process. Know your customer, because I've heard it's basically a financial colonoscopy.
It is exhaustive, and it can take months. You don't just walk in with your passport and a utility bill anymore. For a complex trust or foundation, you must provide certified copies of all the deeds and charters. You must provide an ultimate beneficial owner chart, a UBO chart, which visually maps out exactly who is at the very top of the pyramid, stripping away all the corporate layers.
Sounds like a lot of paperwork.
Oh, it is. You need W-9s for U.S. persons, or W-8BNs for non-U.S. persons to establish tax residency. And crucially, the hardest part, you must prove your source of wealth.
What does that actually mean? Do I just show them my latest tax return?
No. You have to forensically document exactly how you made the money going back decades. If you say you made your fortune selling a manufacturing business in 1995, the bank will ask for the original sale contracts from 1995.
You're kidding.
I'm not. If you say you inherited it, they want the probate documents from your grandparents. If you cannot definitively prove a clean legal origin for the capital, the bank will refuse to open the account.
And what if I've been a lifelong listener to this show and I'm still clinging to the idea that I can use an offshore structure to hide from the taxman?
If anyone still believes that, we need to introduce them to three acronyms that have completely eradicated financial secrecy: CRS, FICI, and the throwback rules.
Okay, lay on me.
Let's start with CRS, the Common Reporting Standards, spearheaded by the OECD. Over 130 countries have signed on to this framework. It is an automatic global exchange of information. If your trust is classified as an investment entity or your foundation is deemed a passive non-financial entity, the bank holding the money is legally required to identify the settlers, protectors, beneficiaries, and council members.
And what do they do with those names?
They report them, along with the exact account balances and the annual income generated, directly to their local government. And then, once a year, that government automatically packages that data and sends it to the tax authority in your home country.
Automatic. You don't sign a release form. You don't even know it's happening. The Cayman government just bulk emails the German tax authority a list of every German citizen with a Cayman account.
Exactly. And for Americans, the net is even tighter because the U.S. didn't join CRS. They built their own, much more aggressive system called FATCA, the Foreign Account Tax Compliance Act. FATCA basically forces every single foreign bank on Earth to act as an unpaid deputy for the IRS. The U.S. told foreign banks, you must identify every American client you have and report their balances directly to us.
And what if a proud Swiss bank says, no, we have strict banking secrecy laws. We refuse to do your job for you?
The U.S. government responds with the financial guillotine.
The guillotine.
Yes. If a foreign bank refuses to comply with FATCA, the U.S. imposes a 30% withholding tax on any U.S.-sourced money flowing through that bank. If that Swiss bank tries to clear a dollar transaction or process a dividend from an American stock, the U.S. just confiscates 30% of it right off the top. It is a financial death penalty for an international bank. So they all comply. They all report their American clients.
So hiding is impossible. But what if an American tries to be clever with the math? What if they set up a foreign non-grantor trust and they decide they just won't take any money out of it for 20 years? They let it sit in the Cayman Islands, growing tax-free, compounding beautifully, and then they finally take one massive distribution when they retire.
The IRS anticipated that exact strategy decades ago. They created something called the U.S. throwback rules. I want you to think of the throwback rules like a punitive financial time machine.
A time machine. Okay.
If a U.S. person gets a distribution from the accumulated income of a foreign trust income that wasn't taxed in the years it was earned, the IRS essentially travels back in time.
How does the time machine work?
The IRS calculates what you would have paid in income taxes in the specific year the trust originally earned that money. They apply the highest possible tax rate to it. Then, they treat it as if you owed them that tax decades ago, and they slap a massive compounding interest charge on top of it for all the years you deferred payment.
Oh, that's brutal.
The interest charge alone can consume the entire distribution. The math is designed to be so punitive that it completely destroys any benefit of offshore tax deferral. For U.S. persons, offshore deferral is dead.
So the era of the secret Swiss bank account hidden inside a Caribbean shell company is just completely over. It's a ghost story we tell at finance campfires.
It is functionally extinct, which raises a critical modern question about substance. You mentioned the Caribbean Shell Company. The research highlights a massive global push for economic substance laws.
What are those?
In the old days, you could pay a lawyer, the British Virgin Islands, a few $1,000s to put a brass plate with your company's name on their office door. That was it. Presto, you were a BVI company enjoying 0% tax, while you sat in London or New York running the business from your laptop.
A mailbox company. Just a piece of paper and a filing cabinet.
Right. Today, if you want the tax benefits of that jurisdiction, you have to prove economic substance. The local government will audit you. You need real physical office space. You need real management making decisions locally. You need full-time employees physically located on the island. And you must prove real local expenditures. You have to actually run the business from the jurisdiction claiming the tax right. If you fail the substance test, your home country will simply look through the entity and tax you directly.
So taxes are brutal, compliance is a sprawling nightmare of paperwork, and privacy is severely restricted. But if you make a mistake with FATCA or CRS, it usually just results in a massive fine or a painful tax bill. There is, however, one area where getting it wrong isn't just a fine. It means your assets are instantly frozen and you might go to prison. Let's move to the geopolitical reality of wealth structuring, the sanctions minefield.
We must approach this impartially, focusing purely on the mechanics of how global sanctions operate, because it is the most critical operational risk in the wealth management industry today. There are several major overlapping regimes: OFAC in the United States, the EU sanctions framework, the UK's OFSI, and the United Nations. They all maintain lists of individuals, companies, and governments that are blocks from the global financial system.
And the rule that seems to trip up the most complex structures is the OFAC 50% rule. Explain the math on this for us, because it's not as simple as just checking a name on a list.
Under U.S. law, the Treasury maintains the SDN list, specially designated nationals. The 50% rule states that if an entity is 50% or more owned, directly or indirectly, by one or more SDNs in aggregate, that entity is automatically blocked, even if the entity itself is not on the sanctions list.
The word aggregate is the trap there. What does that mean in practice?
Let's say you have a commercial real estate holding company. Sanctioned person A owns 26% of it. Sanctioned person B owns 25% of it. Neither of them has majority control, but in aggregate, they own 51%. The instant that second person lands on the list, the entire holding company becomes radioactive. All of the assets are blocked. U.S. banks will instantly freeze its accounts, and any U.S. citizen doing business with that company is committing a crime.
Wow.
And this extends to trusts as well. If a sanctioned person is the settlor, or holds a controlling interest as a beneficiary, the trust assets can be treated as blocked property.
And we saw this play out on an unprecedented, massive scale with the Russia-Ukraine context. Following the 2022 invasion, there were sweeping, coordinated sanctions targeting Russian oligarchs and financial institutions.
Exactly. The scale was staggering. Assets held in offshore trusts and foundations by targeted individuals were frozen across Europe and the UK. Yachts were seized. In the U.S., the REPO task force was established specifically to hunt down and seize these assets. But the secondary effect is what truly shook the wealth management industry to its core. The enablers, the professional trustees, the lawyers drafting the deeds, the foundation council members, the bankers were suddenly hit with secondary sanctions risk.
If you've ever been locked out of your checking account for 3 days just because you tried to wire a few $1,000s and flagged a fraud alert, imagine that on an institutional scale. I want to put this in perspective for you. If you are a professional trustee sitting in a beautiful office in Jersey or the Cayman Islands, and you help a sanctioned individual move money, or you try to restructure their trust to evade these newly imposed blocks, you aren't just facing a regulatory fine or losing your professional license, you are facing severe criminal exposure. You could go to federal prison.
That is the stark reality. The chilling effect on the industry was absolute. And it extends to jurisdictional risk as well. There are comprehensive sanctions on entire nations, places like Iran, North Korea, and Syria. If a trust or foundation has any connection to these jurisdictions, say a beneficiary happens to be living there, or a minor source of funds originated from a business deal there a decade ago, the structure faces extreme risk and total banking exclusion. No top-tier bank will touch it, regardless of how clean the rest of the money is.
So if the environment is this hostile, what are the best practices? How do these multi-million-dollar structures actually survive this minefield?
Pre-establishment screening is now mandatory and exhaustive. You run background checks on everyone, the settlor, the protector, every single beneficiary, the council members, and it has to be ongoing, automated screening because sanctions lists update daily. Furthermore, modern trust deeds now include highly aggressive sanctions clauses.
What does a sanctions clause allow a trustee to do?
It gives the trustee the immediate unilateral power to remove or isolate a beneficiary the moment their name lands on a sanctions list. They don't need to ask permission. They simply excise that beneficiary from the trust to save the remaining assets from being frozen.
It's financial triage. You amputate the sanctioned limb to save the body.
Exactly. It is ruthless, but necessary for survival.
Okay, let's take a breath. We've painted this terrifying picture of global sanctions, IRS throwback time machines, and banks demanding your financial DNA back to the 1980s. It begs the question, if the landscape is this hostile, how is the smart money actually surviving out there? Are they just picking the Cook Islands, wiring the money, and hoping for the best? Because based on everything we've read in this dossier, I doubt it's just one single trust or one single foundation.
You are entirely correct. The smart money doesn't rely on a single point of failure. The ultimate structures don't choose between a trust or a foundation. They use both, they layer them, they weave them together to exploit the specific advantages of different legal systems.
Like a financial lasagna, layer upon layer of legal text.
A very expensive, highly engineered lasagna. Let's look at a common combined structure. A foundation owning a trust. Imagine a wealthy family in Europe. Culturally, they are used to civil law. They understand it. So they establish a Liechtenstein Foundation as the very top of their structure. It feels familiar, it has a public charter, it is a recognized legal entity in their home country. But then, that Liechtenstein Foundation takes its liquid assets and contributes them into an offshore discretionary trust in, say, the Cayman Islands.
Why do that? Why add the extra layer and the extra fees?
Because you get a civil law face, but common law protection. The Foundation Council in Liechtenstein controls the high-level strategy and interfaces with the family, but the Cayman trustee controls the day-to-day asset management. The trust provides an incredible, deeply entrenched layer of common law asset protection that insulates the core wealth from any claims that might be made against the foundation itself in Europe. You get the best of both worlds.
And you can flip it too, right? A trust owning a foundation.
Yes. You set up an offshore discretionary trust, giving you that amazing, flexible ability to distribute money to different generations as needed. But the trust doesn't own the real estate directly. Instead, the trust holds 100% of the economic interest in a private interest foundation in Panama. The foundation, as a legal entity, is the vehicle that actually goes out and buys the commercial real estate in Latin America. Because local civil law courts understand how a foundation owns property much better than how a common law trust owns it.
The dossier details something called layered architecture, which is how the massive multi-billion-dollar family offices operate. We're talking level 1, level 2, level 3. Let's walk through this vertical stack.
This is the pinnacle of structuring. Level 1 is the ultimate beneficial ownership layer. This is your Cayman Trust or your Liechtenstein Foundation. It sits at the very top of the pyramid. It's entirely passive. It just holds shares. Level 2 is the holding company layer. This is almost never in the same country as level 1. You put your holding company in a treaty-efficient country like the Netherlands, Ireland, or Luxembourg.
We mentioned treaties earlier. Why the Netherlands? Explain the mechanics of how a treaty actually saves them money here.
Let's say you own a highly profitable software company in Germany. Normally, if that German company sends its profits out of the country to an owner in the Caribbean, the German government takes a massive withholding tax right off the top, sometimes 25% or more. It's an exit tax. But because the Netherlands spent decades negotiating specific, highly favorable double taxation treaties with Germany and the rest of Europe, that exit tax drops to zero. Germany allows the money to flow to the Netherlands tax-free, and the Netherlands has a 100% participation exemption, meaning they don't tax incoming dividends from subsidiaries either.
So the money escapes the high-tax country legally, flows through the Dutch holding company untouched, and then level 2 pushes it up to level 1 in the zero-tax Cayman Islands.
Precisely. And level 3, at the bottom of the pyramid, are your actual operating companies located all over the globe. The factories, the software firms, the real estate developers. The money is made locally at level 3, flows up tax-free to level 2 in the Netherlands, and is ultimately owned and protected from lawsuits at level 1 in the Caymans.
So the natural consequence of that is jurisdiction arbitrage. You use the Netherlands for its incredible tax treaties, you use the Cayman Islands for its impenetrable trust law, and you use Switzerland for its premier banking. You completely decouple where you physically live from where your assets legally live.
Jurisdiction arbitrage is the perfect term. Let's take this theoretical architecture and apply it to the 4 practical case studies outlined in the dossier to really make it concrete. Let's walk through them step by step. Case study: one many U.S. family with $50 million. They have a successful tech company, real estate, and a large liquid portfolio.
Okay, we know from our earlier discussion that they cannot use an offshore foundation because the IRS will punish them. So what do they build to protect that $50 million?
They build a purely domestic, highly optimized fortress. At the core, they establish a Salzgitter dynasty trust to hold their liquid investments in real estate. This gives them top-tier creditor protection and avoids state income tax. Crucially, they structure it as an IDGT, an intentionally defective grantor trust.
Right, the defective trust. So they're going to pay the income taxes out of their own pocket to let the trust grow tax-free. What about the tech company?
They execute an installment sale. They sell the tech company to the IDGT in exchange for a long-term promissory note. This freezes the value of their estate today. If the tech company explodes in value from $10 million to $100 million over the next decade, all of that $90 million in explosive growth happens entirely inside the trust, completely outside of the 40% estate tax net.
But they still have the promissory note paying them a steady income.
Exactly. Then they set up an ILITE to hold a massive life insurance policy to pay whatever final estate taxes remain on their personal assets when they die. And finally, to handle their philanthropy, they set up a standard U.S. 501c3 private foundation, allowing them to take immediate charitable deductions on their income taxes while funding public causes.
Clean, totally domestic, entirely legal. Now, what about case study two, a European family with $30 million and a lucrative German operating business?
Completely different architecture, driven by different laws. Their primary fear isn't the IRS. Their primary fear is German forced heirship laws dictating who gets their business when they die. So they use a Liechtenstein Stiftung as the ultimate owner at the top of the pyramid. The Stiftung's charter explicitly bypasses the German heirship rules.
And below the Stiftung,
Below that, they use a Netherlands holding BV to manage their European real estate portfolio tax efficiently, taking advantage of the treaty network we discussed. And to hold the actual shares of the German operating business, they use a Liechtenstein Anstalt, that unique hybrid entity. The Anstalt acts as a nominee, legally holding the shares, which keeps the family's direct ownership private from the public German corporate registries.
case study three, a Latin American family. Let's say they live in Colombia. They aren't U.S. citizens, they don't have green cards, but they own a $5 million luxury condo in Miami and an $8 million U.S. stock portfolio at Morgan Stanley.
This scenario is a classic, devastating trap that catches many wealthy foreigners. If a non-resident alien dies owning U.S. real estate or U.S. stocks directly in their own name, the IRS will hit their heirs with a massive U.S. estate tax up to 40%, and they only get a tiny $60,000 exemption. To solve this, the family bifurcates their wealth. They set up a Panama Foundation to hold their local Latin American business interests because Panama is culturally familiar, cost-effective, and provides excellent local privacy.
But Panama won't save them from the IRS on the Miami condo.
Right. For the U.S. assets, they set up a Cayman Trust. The Cayman Trust does not buy the condo directly. Instead, the Cayman Trust forms and owns a U.S. LLC, and the LLC buys the Miami condo and holds the brokerage account.
Why the LLC in the middle?
Because under U.S. tax law, a non-U.S. person's interest in a foreign trust is generally not subject to U.S. estate tax, even if that underlying structure holds U.S. assets through a corporate blocker like an LLC. The LLC provides local liability protection if someone slips and falls in the condo, and the Cayman Trust at the top legally firewalls the entire $13 million from the U.S. estate tax. The exposure drops to zero.
That is incredibly elegant. Let's do one more. Case study four, a Middle Eastern family with $100 million. They have regional real estate, global equities, and they have a strict requirement to comply with Islamic Sharia law for their succession planning.
In this scenario, they don't need to go to the Caribbean or Europe. They use specialized regional hubs that understand their cultural and legal needs. They set up a DIFC trust at the Dubai International Financial Center or an ADGM foundation in Abu Dhabi. Both of these jurisdictions have spent the last decade drafting specialized, world-class legislation specifically for Sharia-compliant wealth vehicles.
How does the structure enforce Sharia law?
The trust deed or foundation charter explicitly incorporates Islamic succession principles, dictating exactly how the wealth must be divided among heirs according to religious text. Furthermore, they use a board of Sharia scholars to audit the investment portfolio to ensure the funds aren't invested in prohibited industries like alcohol, gambling, or highly leveraged conventional finance. The legal structure enforces both the religious mandate and the asset protection.
So after walking through all of that, what does this all mean for you, the listener? It means that when someone asks, should I use a trust or a foundation, the answer at this level of wealth is almost never just one or the other. The answer is usually yes, both. Plus an LLC, a Dutch holding company, and a protector.
It is bespoke financial architecture. You are building a custom machine tailored to the specific legal threats of your home country. But we cannot leave this topic without a severe reality check, because this can go spectacularly, disastrously wrong.
Which brings us to our final point, key risks and common pitfalls. The research dossier is very clear that having a fancy binder full of legal documents doesn't make you invincible. The biggest risk highlighted is look-through risk. What does that actually mean in a courtroom?
We just described these beautiful multi-layered structures. But if you layer all these entities and they lack real operational substance, if the Dutch holding company is just a mailbox, if the foundation in Panama is just a piece of paper in a drawer, and the founder is still pulling all the strings and treating the bank accounts like a personal ATM, courts and tax authorities are increasingly aggressive about applying a look-through analysis.
They just ignore the structure entirely.
Yes, they will peer right through the paper walls, declare the entire elaborate architecture a sham, pierce the corporate veil, and tax or sue the individual directly as if the entities never existed. The
Yep.
paper shields will not hold up to a forensic audit by the IRS or a motivated plaintiff.
And then there's the cost. Complexity isn't cheap. You don't set this up on LegalZoom.
Not at all. A multi-layer, multi-jurisdictional structure requires constant, ongoing coordination between trust lawyers in the Caymans, tax advisors in the U.S., foundation counsels in Liechtenstein, and bankers in Switzerland. The dossier notes it can easily cost over $100,000 a year, just in professional maintenance fees, accounting, and compliance filings. If you don't have at least $10 million to $20 million to structure, the annual fees will eat your investment returns alive. It is a tool for the ultra-wealthy, not the mass affluent.
And finally, governance failures. You can hire the best lawyers in London or New York to draft the perfect documents, but if you don't operate the structure correctly on a Tuesday afternoon, it's useless.
Setting up the structure and paying the lawyers is only 10% of the work. Operating it legally day in and day out is the other 90%. If a foundation counsel holds fake board meetings and just backdates the minutes, or if the trust protector is just rubber stamping everything the settler demands via text message, a court will discover that. You must respect the entities you create. If you treat it like a sham, the court will rule that it is a sham.
All right, let's bring this home. We've covered an immense amount of ground today. We started by exploring the fundamental DNA, the common law, fiduciary relationship of a trust, which is the friend with the backpack, versus the civil law corporate entity of a foundation, the programmed robot. We navigated the control dilemma, the danger of sham trusts, and the ticking clocks of fraudulent transfer lookbacks.
We examined how the U.S. weaponizes its tax code, forcing foundations to be purely charitable while allowing highly engineered domestic trusts like DRANTs and IDGTs for generational asset protection. We toured the offshore safe havens from the Cook Islands to Liechtenstein, explaining why forced airship drives Europeans to foundations and litigation drives Americans to trusts.
We confronted the crushing reality of global banking compliance, the colonoscopy of KYC, the automatic data sharing of CRS, the withholding guillotine of FACA, and the terrifying strict liability nature of OFAC sanctions. And finally, we looked at the architectural beauty of combining these tools through jurisdiction arbitrage.
It is a vastly complex ecosystem, but it operates on very logical, mechanical rules once you understand the underlying legal history.
And here's why this matters to you, the listener. Even if you aren't currently sitting down with your lawyers to structure a $50 million international portfolio, understanding this matters. Knowing how capital flows across borders, how it is legally walled off from liability, how treaties function, and how sovereign jurisdictions actively compete with each other to attract wealth, that makes you vastly more literate in how the global economy actually functions. When you read a headline about a billionaire paying zero taxes, you now understand the mechanics of how they did it legally, rather than just assuming it was a briefcase of cash in a dark room.
It strips away the mystery and replaces it with an understanding of the mechanics.
That makes sense, and it also explains why the landscape is constantly shifting. I want to leave you with a final thought, something that wasn't explicitly covered in our main discussion today, but is the natural conclusion to everything we've talked about regarding compliance and reporting. With the massive rise of global UBO registers, ultimate beneficial owner lists where governments demand to know exactly who owns what, and the new Corporate Transparency Act in the U.S., absolute financial privacy is effectively dead for everyone except perhaps sovereign states. So the question for wealth structuring isn't, how do I hide my wealth anymore? That era is over. The question is now, how do I structure it so perfectly, so legally bulletproof that I don't care who knows about it? Because when the legal architecture is sound, transparency isn't a threat.
That is a profound shift in mindset for the entire wealth management industry, moving from secrecy to invulnerability.
It's the difference between trying to be a ghost and building a vault so incredibly strong that you can leave the blueprints taped to the front door. Something to think about. Thank you to our expert for this incredible analysis, and thank you for joining us on this deep dive.